I'm so sorry. I'm sorry. Please. I'm so sorry. I'm so sorry for what they lost.
The area where this happened, the location was very dark, and she just didn't see that there was an accident in front of her. She was a home health care provider, and she did help a lot of people while she was out in the field.
Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Is going to call 2022 CR 2127, State of Texas versus Hannah Marie Smith. Could I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
I can get out of this. Smith?
And are you Ms. Smith?
Yes, ma'am.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the count 2 charge of manslaughter and waiving counts 1, 3, and 4.
No objection.
All right, Ms. Smith, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of manslaughter? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're waiving counts 1, 3, and 4. Punishments to be assessed at 6 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in count 2. How do you plead? Guilty, not guilty, or no contest?
No contest.
All right. After reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty.
Judge, may I clarify one of my responses in response to your question about motions?
Yes.
I said that I hadn't filed any. I'm not sure if Ms. Cordy did, so I don't want to represent to the court because I think she may have filed some evidentiary motions. I did file some non-evidentiary motions, but I wanted to make sure that if Ms. Cordy did, I didn't represent that there were none filed.
All right. And I can tell you from my review of the court's docket sheet that there was no motions that were heard.
Okay.
And there were some motions that were filed, but none that were heard.
I just didn't want to make any misrepresentation.
All right. So the court is finding you guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
On behalf of my client, Judge, this is a case that was a tribal type case based upon the evidence that she reviewed. My client has made the decision to come in and accept responsibility for her portion in this accident that happened. She's extremely remorseful. She wants to get this behind her, and she wanted to say her apologies to the family that the area where this happened, the location was very dark, and she just didn't see that there was an accident in front of her. She has Graves' disease, and she's been pretty ill at the jail. So she's hoping that this time will pass, and hopefully that she can get her life back together. She was a home health care provider, and she did help a lot of people while she was out in the field.
All right, anything from the state?
We have victim impact.
All right. Anything you wish to say, Ms. Smith?
I'm sorry, please. I'm so sorry. I'm so sorry for what they lost.
All right, anything else from either side?
No, Your Honor.
All right, I'm going to follow your agreement. I'm going to sentence you to 6 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So, Ms. Smith, there's going to be a victim impact statement. What I can tell you is I know that sometimes emotions and tempers run high, because in this court, we'll deal, as your counsel will tell you, and the state will tell you, we're dealing with serious cases, major felonies. But I do require that everyone treats everybody with respect and kindness. So there are some persons who want to say something to you. Just listen, internalize it. Okay. Noriega. All right. Why are you winking at me? You winked from the side. Here's the thing. Here's the thing. We are not on that level. So don't come at me. Do not come at me on that level. We're not on that level.
Quiet.
All right. You want to take him?
Take them.
Yeah.
Want to move forward in my life and just be a better person for my family, for members of my community, and just get past this and just move forward. I'm so to be making mistakes and
But the question is, why do you, I mean, these are not mistakes, these are choices. Why do you keep making the same choices? Yeah, you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant. Calling 2025 CR 0000069, State versus Xavier Chamberlain. Could I have parties announced?
Opinion for the state of Texas.
Renee Munoz on behalf of Mr. Chamberlain.
And are you Mr. Chamberlain?
good morning, I guess, ma'am.
All right, according to the plea bargain agreement, just 1 second, we'll wait till they're finished over here. All right, you entered a plea on May 27th of no contest to assault a family household member with a previous conviction. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. This is to run concurrent with 2025 CR 0000071, 2025 CR 0000092. Those cause numbers, have you been sentenced on those, or those motions to revoke?
They're all new cases that got indicted. He doesn't have any pending motions to revoke. It's just there was a plea on as to some and then summary BTIC to resolve.
All right. All right. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Any objections?
No objection by the defense.
No, well, I'm silent, but I'd just like to speak.
All right. All right. Do you have any witnesses?
No, Your Honor, I believe, just a procedural background, justification as to what we believe is an appropriate course of action that we would ask the court to follow.
All right,
as
just
well
one
as-
second. State, any witnesses?
None from the state.
All right, then you may proceed.
Thank you, Your Honor. In reference to Mr. Chamberlain, I have been on his case, ever since he got picked up on these offenses in October. I've met with him routinely, and this is an individual that I believe is grappling with drug addiction and does not have an innate sense of criminality, Your Honor. Ever since he's been in pending custody in the Burnett County Jail, he has done family violence individual counseling. I have those forms here, if I may show the court.
Any objection?
And so he has been working on those things. He has been learning about boundaries and effective ways to deal with stressors in his life as well, to not take him out in a violent way, Judge. There's some cases pending here, but if the court does take note, one of the offenses, there was no bodily injuries observed by law enforcement, and the other one, there was a small, slight little scratch. In dealing with the case and talking about the evidence and our avenues for taking this in front of the court in terms of sentencing, we did talk about certain inconsistencies within some of the reports, but that was more so before he accepted the plea. So he does accept responsibility. He knows that he messed up. He knows that this was a toxic relationship with an ex that he shouldn't have been continuing, but he was in the midst of drug addiction. As noted in the PSI, he was under the influence of drugs at the time of these offenses, Judge. Also in the PSI, he has never had residential treatments. He has had outpatient treatment before, but because we believe that his needs are severe in terms of his daily methamphetamine usage before he got picked up, we feel like inpatient treatment would be more so suitable for him to get a grasp on his issues that he's dealing with. We're looking, Your Honor, in terms of his whole life and his future down the road, and in terms of serving the community and also helping Mr. Chamberlain work towards bettering himself. We feel that inpatient treatment would be more conducive in that we're able to address the root cause of this and hopefully put a stop to this from ever occurring again. If Mr. Chamberlain is institutionalized or incarcerated without the proper form of treatment, we feel that we may just be repeating this pattern of events that has been going on. Mr. Chamberlain has been to prison before, Your Honor, but this was about 20 years ago. When he was younger, did not get the appropriate treatment. He was essentially sent to TDC, released out, and had been battling homelessness as well as drug abuse. For these reasons, Your Honor, we're requesting a period of a deferred adjudication as long as the court sees fit with inpatient treatments. And I did speak about if the court did approve inpatient treatment, what that would be looking like in terms of transfer to a facility and then having to be compliant with the terms of community supervision thereafter. Before Mr. Chamberlain was picked up on this offense, he did start school at St. Philip's College. He was about 1 month into that program until he got picked up on his offense and did not have the opportunity to bond out. But he had been working towards his HVAC certification, where he wanted to work in that capacity in terms of a career for himself, Judge. So in looking at his criminal history, he does have minor things such as theft, drug possession, burglary. These are all things that I think were tied with drug addiction, drug usage. So we're asking that the court take a look to see if he's eligible to address the root cause of that addiction to stop this cycle of institutionalization.
All right, is there anything you wish to say, sir?
Yes, ma'am.
You want to raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
David Chamberlain.
All right, you may proceed. What would you like to say?
Your Honor, I take full accountability for my actions and I'm very remorseful, but at the same time, I know that I learned a lot from this experience. I'm not the same person I was a year ago. I just want to move forward in my life and just be a better person for my family, for members of my community, and just get past this and just move forward. I'm so to be making mistakes and
But the question is, why do you, I mean, these are not mistakes, these are choices. Why do you keep making the same choices? Because you have previous convictions for assaultive behavior. That's why this is a assault with a second conviction. So why do you keep making these same decisions? And then we have the violation of protective order. So there's a protective order in place. And when people violate protective orders, those are court orders. So that tells the court if you're violating that you won't follow my orders because you're already violating a court's order.
I was under the influence of drugs and
Sorry, what?
I was under the influence of narcotics, Your Honor, and I'm just trying to seek opportunity for treatment.
But I mean, yeah, you're under the influence of narcotics, but it didn't stop you from going to the location of the complainant and striking the complainant.
I was living there, Your Honor.
But wasn't there a protective order for you not to be at that location?
Not to my knowledge, and not until I was arrested was I informed of the protective order. My ex never told me about it.
Okay. All right. Is there anything else? And on this case, what I can tell you, I don't have the trial court certification of defendant's rights to appeal. I know you probably filed it, but it's lost somewhere. So if you could do another one for me, please.
Yes, Judge, would that be one I have to get from them, or do they have them on the wall?
They should have them on the wall now.
Yes.
He took the last one.
Oh.
The clerks
Yeah,
may
be
have
quick,
some
man.
more. All right, the cause number is 2025 CR 00069.
Things go like hotcakes, Your Honor, these nice ones.
Oh, yeah.
They're custody. They repeat this, I mean, it's just a formality of the wow. What's that? Your Honor, can we tender it?
Yes, thank you. All right, any further witnesses?
None from the state. None from the defense, Your Honor.
All right, so Mr. Chamberlain, I want you to know your attorney did a very good job for you because you have numerous cases that are open and pending, right?
Yes, Your Honor.
I just don't think that you're a good candidate for probation. So I'm going to find you guilty. There's an affirmative finding of family violence. There's to be no contact with the complainant, a $1,500 fine, time and money to run concurrently. This will run concurrent with 2025 CR 00071, 2025 CR 00092. Take in consideration 2025 CR 00070, 2025 AL 002118. Court will give you credit for any time served, the therapeutic community, and 5 years in the prison. With the therapeutic community, I have no jurisdiction to mandate that you be in the program, but they'll know in the judgment that I'm requesting the therapeutic community for you. So there may be either mental health issues or drug issues. You're still going to have to request the program. You understand?
Hannah Marie Smith, a home healthcare provider, stood before Judge Stephanie Boyd in Behar County after being charged with manslaughter following a fatal crash. The state waived 3 of the 4 counts and proceeded on count 2, manslaughter, a second-degree felony carrying 2 to 20 years in prison. Smith entered a no-contest plea, waiving her right to a jury trial and her right to appeal. Her attorney argued the crash occurred on a poorly lit road where Smith, who suffers from Graves' disease, simply never saw the accident ahead of her. He emphasized her history of service as a caregiver and her genuine remorse. Before sentencing, Smith addressed the court in a barely audible voice, apologizing to the victim's family and admitting she was terrified. Judge Boyd acknowledged the gravity of the case and reminded those present that respect and decorum were required regardless of the emotions in the room. Following the plea agreement, Judge Boyd sentenced Smith to 6 years in the Texas Department of Criminal Justice with credit for time served. As a felony convict, she is permanently prohibited from owning or possessing weapons or ammunition.